This conference will now be recorded.
Okay, good morning, everybody. I will admit I'm a little shocked and awed that the room is not packed and we don't have 100 agents online. I say that because I love this subject so much, and so I naturally think that everybody else loves it as well. I also know that knowledge of the contracts is your unfair competitive advantage. And so I fully expect other agents to see it the same way. Nevertheless, I'm delighted that you are here, and I'm going to give you about 15 minutes. So go ahead and start taking your test. Move as quickly as you can. Don't sweat the details. Make your best guess and keep on going. You've got 50 questions, so that gives you about 22 seconds per question. Go. Those of you who are online, I emailed out a copy of the quiz this morning, so go ahead and start taking it there. While you're talking, while you're taking, good morning. Shannon, would you like to be talking? No. No, okay. Okay. Oh, if you saw the questions, you would know. These, I mean, I start out with an easy one, but it ramps up pretty quick. All right, that's right. First one is kindergarten question. Okay. Your 22 seconds are ticking away. Come on. Come on. Kevin's got the written exam if you want to grab one. 22 seconds per question is about all we're allowing. So you got to read fast, answer quick. I might play a little James Taylor or something while we're waiting here. No true or false, just multiple choice. Oh, this is the ad to get to the music. Give it about 5 more seconds. Oh, there's another end, so we'll turn it. I know. We could get rid of those ads if I'd pay them more money. Okay. Let's see what we got here. Here we go. I'm John Denver.
This conference will now be recorded.
Okay, thank you everybody for playing along and completing the contract mastery quiz. I think what we're going to do is just go through one question at a time. and I'll give you the answers and we'll talk about them. And then depending on time at the end, I may just race through and give you the rest of the answers so that you can tally your score. Okay, sound good? All right, so let's jump in here. Question 1, when does TREC require that the IABS be presented and explained? Anybody want to take that one? C, at first substantive conversation. Anybody miss that one? That was the easiest question of all 50, so I kind of eased you into it. Answer C.
However, it's an easy question, but when actually dealing with a customer, it's not that easy.
It's not that easy to present it.
Yeah.
Yes. So I'm going to ask a follow-up question. This is kind of a 1A. Does TREC require that the IABS be in your email signature? That's kind of a tricky question. They don't want it in your signature. That doesn't count. They want it above the signature. So let me rephrase. Does TREC require that the IABS and the consumer protection notice be in your email above the signature? The answer is no. They only require that the IABS be presented at first substantive conversation. But one of the ways that it can be presented is in the body of an email. Correct. That's why I say the body of the email above the signature. So agents have taken to putting those required disclosures in their email kind of as a backdoor way of just covering themselves. Because if you have, an early conversation via email, then you got it. Okay. But no, TREC does not require that. Okay. Little known fact. Aren't you glad you're here? Number 2, what document authorizes a listing agent to move into an intermediary position? Answer is A, C. Who said D? D for David. David is correct. Okay, listen carefully. What document authorizes a listing agent to move into an intermediary position? Okay. Oh, wait a minute. Hold on. Whoa, I wrote down the wrong answer. David, I'm so sorry. I take it back. The correct answer is A. So I'm so sorry. Somebody throw me a pencil. I got an extra pencil? I need to correct this on my key. Okay. So thank y'all for sticking by your guns. The answer is A. 3, if you prepare offer documents for an unrepresented buyer on your listing, are you an intermediary? Or what are you? Or what is the correct answer? Is that what your answer is, Nancy? No. Did everybody say B? Anybody choose anything else? What'd you say? So here's the key, and this is why the question. Intermediary means you represent both parties. And the question says if you're working with an unrepresented buyer. So that's your cue right there that you cannot be an intermediary in this situation because you're not representing both parties. Does that make sense? Okay, very good. Number 4. Where is the best place to obtain a completed IABS form? I should have said call Frank because that's what everybody does. But Frank, what is our new broker's name? What's his phone number? What's his email address? What's his license number? No, I'm not. The answer is D. On HAR, they already have it personalized, customized, completely filled out for you. Go to the dashboard, type in IABS in the search window, and your completed form will pop up with a link in case you want to put it on your website or email. Number 5, the consumer protection notice does what? This was a little bit harder question. So A, instructs consumers how to file a fair housing complaint. No, doesn't even mention fair housing. Explains consumer rights under the Deceptive Trade Practices Act. It does not even mention the DTPA. We should read this doggone thing sometime. Oh, there. You be nice to your agent. Don't we wish that's what it said? It has to be C. Tells consumers how to check the status of a licensee. It does also, but file a complaint with whom? With TREC.
Oh, not fair.
Exactly. So the answer is C, tells consumers how to check the status of a licensee. We can learn a lot by reading these documents. Number 6, the buyer-tenant representation agreement requires the buyer, there's a little typo, the buyer, to pay their broker a commission under the following circumstances. What would the correct answer be? Only if the listing broker doesn't pay the full commission agreed upon in the representation agreement. Does everybody agree it's B? We got groupthink going on here? Good thing. Correct answer is B. How y'all doing so far? Anybody got all 6 correct? Anybody got 5 correct? Woo, woo, woo. Okay, very nice. Number 7. The buyer-tenant representation agreement obligates the buyer to pay the buyer broker the full commission listed in the agreement. A, B, C, or D? B says if the broker successfully closes the sale. No, who said that? So if the broker successfully closes the sale, who typically pays the commission? The listing broker, yes, the seller through the listing broker. So in that situation, they're not going to be required to pay it. If it's not A, what could it be? Or not B, what could it be? D for dog is correct. If the buyer breaches the agreement or the sale contract, it is the buyer and not the listing broker or the seller who is required to pay that commission. That's right. Yes.
I mean, I've seen that just from like working with agents so often, like, you know, it doesn't work out, they change their mind. How many times do you guys actually enforce that?
I've never seen it enforced, but as a broker, I was eager to do it if the buyer breached the agreement and then tried to go do something else with another agent, then I would have absolutely sued for that. Okay, here we go. Number 8, if the buyer does not have a buyer-tenant representation agreement with the agent who's assisting them in purchasing a home, and no representation agreement has been made orally, the agent represents whom? I'm giving half credit for that answer. What is technically the correct answer? The listing broker. That's exactly right. And the agent becomes a sub-agent of the listing broker. I gave you half credit. Half credit. That's not bad. Number 9. If the buyer-tenant representation agreement specifies a 3% commission to the buyer's broker, and a sale contract is signed with a builder who offers 3% to the buyer's broker plus a $10,000 bonus, what happens with the bonus? What? It doesn't get credited towards buyer closing costs? So I actually, you're correct. The answer is B. It is paid to the buyer's broker. I had a builder's representative tell my client, the buyer, oh, there's a bonus on this transaction. I'm sure your agent will credit that towards your closing costs. Guess what? I did not. It was highly doubtful, and I did not. And it ruined my relationship with those buyers. But doggone it, I wasn't walking away from a $10,000 commission that I was entitled to and worked hard for. Oh, I was so upset about it. It was David Weekley. I was shocked that they didn't have a more professional representative on that situation. All right, here we go. Number 10. If the buyer representation agreement expires on February 1st and the protection period is 10 days, and the buyer hires another agent to represent them in purchasing a home on February 5th, who is paid the commission on the home purchase? The new broker. What about the protection agreement? You guys are so smart. The correct answer is A, the new broker, because the protection period is only valid if the buyer has not signed another representation agreement. And it says quite clearly here that they did. So that protection period, and not much protection. Don't take much shelter in that. Number 11, when showing or previewing a home, who may take photos or videos of the property? The buyer? Okay. Most people are going with C. So the correct answer is C. Nobody without the owner's permission. Of course, the listing agreement gives the listing agent permission to take photos and video. But if we're wandering through, and we often do this because right now we're in a market where sometimes people are putting offers on homes they've never even seen. Of course, you're such a good above and beyond service agent. You're going through, let me do a walkthrough video for you. Let me take pictures. You better get the permission of the seller first, because you could be disclosing issues of a private nature in that home that they didn't even permit in the listing photos. They may have put some stuff away for the listing photos, then they go back to living in the home, and now all of a sudden you're disclosing they got a gun collection, they got a Fabergé egg in the living room. Well, yes, that's when it's going to be an issue, but the law is the same. You cannot go in and photograph and video a person's home without their permission, even if it's listed for sale. Okay. Number 12. Yeah. To reduce the risk of wire fraud, the following practice should be followed. A, B, C, or D? B? Are we talking about boy or dog? Okay, Thomas, let's read B, Thomas, and I want you to tell me why boy is the wrong answer. If the buyer receives the wire instructions from the title company, the buyer should call the phone number provided in the email message to verify its authenticity. That's exactly right. The fraudsters put their own phone number in the email. So that's why we verify using a separate phone number obtained independently. Would that be correct, Shanna? It's D for dog. And by the way, all of that is stated in the wire fraud notice. Okay. Number 13, you guys are doing really good. In the addendum for sale of other property by buyer, commonly known as the what? We don't typically walk around talking about the addendum for sale of other property for the contingency addendum. In the contingency addendum, what happens if the contingency is not satisfied or waived by the stated date? A, B, C, or D? I hear a C. The rest of the group is pretty quiet. The answer is apple. The contract will terminate automatically and the earnest money will be refunded to the buyer. How do we know that? It says that in the addendum. Yes.
What does it mean the contingency is waived? Does that mean it's not valid anymore?
What it means is the sale is no longer contingent upon the sale of the buyer's home. The buyer's saying, I'm going to buy that house regardless. Okay, so they're waiving the contingency. Okay, I know the language is a little complicated. Number 14, Yeah. If the seller accepts another contract and notifies the buyer that they must waive the contingency within the agreed upon number of days, what happens if the buyers do nothing? I heard a C for cat. Anybody else want to play? I heard a D for dog. C. In this case, dogs drool and cats rule. The answer is C. The contract automatically terminates when the agreed upon number of days is completed and the earnest money is returned to the buyer. So the seller informs the buyer, we got another contract, you got 3 days to waive this contingency or not. And if the buyer just goes to sleep, well, it's going to be terminated. The buyer's going to get the earnest money back and the new buyer's going to step into first position. Number 15, if the buyer waives the contingency, but then can't close because they couldn't sell the property named in the addendum, what options does the seller have? Exactly, D for dog, all the above. They can terminate the contract and retain the earnest money, sue the buyer to make them purchase the home. And by the way, where are those two options described in the 1 to 4 family contract? Y'all need to know this, right? I mean it sincerely. You need to memorize this. Paragraph 15. Paragraph 15 outlines the remedies of the non-defaulting party in case of a default. Isn't that right, Michael? That's right. There we go. Paragraph 15. But absolutely, yes, they can do any one of those things. Number 16. How does a buyer waive the contingency? A, B, C, or D? I heard a B for boy. Anybody else? Different opinion? By asking their agent to notify the listing agent in writing. That does sound good, but we're going with boy. By giving notice to the seller of the waiver in writing and making an additional earnest money deposit. That is required in the contingency addendum. Sometimes that's tricky because in the 1 to 4 family, you put in the earnest money deposit and then there's another line for a second earnest money deposit. And we normally do what with that? We leave it blank, right? We think it's not necessary, but in a contingency addendum, it is necessary if they're going to waive the contingency. Number 17, in the addendum for property subject to mandatory membership in a property owner association, AKA the HOA Addendum, who pays for required deposits into the reserve fund if such deposits are required? C, the seller pays the negotiated amount and the buyer pays any excess. We're going to flip that on its head and say just the opposite, because that's what the HOA addendum says. The buyer pays the negotiated amount and the seller pays any excess. No, it's the other way around. You negotiate the amount the buyer is going to pay, $250, $400, $600, whatever it is. And then anything above that is the seller's responsibility. And it specifically says in listing the expenses that are included there, reserves, which would typically be reserved for repairs, capital projects in the future, that type thing.
So buyers wrong, it has to be buyer.
Correct. Yes, it's not the buyer pays because the buyer's payment is limited by the amount of funds you write in that line. Okay, so the answer is dog, D. Number 18. In what circumstances would you use the registration agreement between broker and owner? Y'all not real familiar with this one, are you? I heard a B and a D. Correct answer is boy. when presenting an offer on an unlisted property. And I get this question all the time, right? We found a FSBO. I knocked on the door. The homeowner is willing to consider an offer that I might bring, but how are you going to memorialize the commission agreement with that homeowner? What if they agree to pay you 3%? What document do you have confirming that? There's no listing agreement, right? So you simply do the registration agreement. Yes?
What if there's no listing, it's unlisted property, but the one that's owner owned, but the one that you're dealing with is a property manager who happens to be an agent, but they didn't list it.
Okay, so there's a home that your buyer wants to purchase. It's unlisted. It's represented by a property manager. Okay, all right. We'll let that one go then. Okay, so next time you want to make an offer on a FSBO, remember registration agreement. Number 19, what other documents would be used in conjunction with the registration agreement? IABS, residential buyer tenant rep agreement, seller's disclosure notice. What do you think? A D, is what I heard? D for dog? Well, D doesn't say all the above, does it? It does? Okay, it should not. And I corrected this on mine. Is that not fair of me? Can I change the answers? So the correct answer is both A and C. That's what I changed D to, is both A and C. So you may want to write that down. The buyer rep agreement is not necessarily part of this. And here's why. If you read the registration agreement between owner and broker, it actually states in there, there's a checkbox to describe your relationship with the parties. And the options are, broker will represent owner only, in which case there would be no buyer representation agreement. Broker will represent buyer only, in which case there would be, or broker can represent both parties as intermediary, in which case there would be a buyer tenant rep agreement. Where do you find any contract documents? You personally, where do you go? My templates where? That go to .loop and search documents using the keyword registration. Anytime you want to find a contract document, think of the most unique word in the title and then search for it that way. And I don't care if you're on HAR, zip form, .loop, transaction desk, SkySlope, search on the most unique word and you will most likely find it. Okie dokies. We're on number 20. We're making good progress. I think we're going to get through this. Can a representation agreement be established without written documents? A, B, C, or D? We got an argument going, don't we? Who all says A? No, representation agreements must be in writing. Who says B? And the B's have it. The B's have it. So representation agreements can be established orally. In other words, hey, Thomas, would you help me find a home? Put in an offer for me? If he says, yes, we have an agreement. You're my representative legally. Yes, absolutely. Now, why do we want it in writing? That's right. There's no enforceable right to compensation without a written agreement. And one more thing. There's another piece to this. Why else do we want it in writing? Because intermediary status can only be granted by written agreement. So without a written buyer rep agreement, you cannot show that buyer any EXP listings. Yes, Nancy?
So
You're talking about open houses, we got all these people coming in, you don't wanna ask them, if they got a realtor, right? Okay, so they say that they're working with a realtor, it might not be, because they don't have a representation agreement, but that has been established between them, just not in writing. I'm just trying to figure out how to justify the answer to that question. That not being in writing, because if you can establish by just saying, yes, you're my realtor, and you want to do this party, and then, but yet, you know what I'm saying, somebody else comes along.
So just because you show somebody a house doesn't mean that you have established a representation agreement. It has to be established orally. Thomas, will you represent me? Okay, if you just go show me a couple of houses, there's no representation agreement established. Okay. All right, do you know the difference between verbal and oral? Verbal refers to any type of word communication. It can be in writing, it could be graphic, or it could be oral. Oral refers solely to spoken communication. So oral agreement can establish agency. 21, when an agent presents an offer on behalf of an unrepresented buyer for a property listed by a different broker, what is the agent's status? B, subagent of the listing broker. That's exactly right. And by the way, how much should that subagent expect to get paid? And so that's a correct answer, Thomas, but they're also right. The subagent should expect to be paid what's offered on the MLS to a subagent, which is typically zero. Listing brokers do not enjoy compensating subagents because subagents create liability and risk for the listing broker. So they want, if the listing broker's position is, you want to present an offer on one of our listings, you better represent your buyer. Okay. Number 22. You've listed a property and learned about a material defect which the seller has not disclosed. What should you do? A, B, C, or D? I heard an A and I heard a D. Let's take D. Write an addendum to the seller's disclosure notice. Does anybody have alarm bells going off already? Whose disclosure notice? The sellers, not the agents. Okay, disclosing the material defect and ask the seller to sign it. We don't even fill out the seller's disclosure at the seller's request, right? They have to fill it out in their own hand, or if they can't write, then they get their niece, their nephew, their cousin, somebody. We don't touch that seller's disclosure, right?
Let them know if you found this and we need you to disclose it and give them the option of whether or not to do it.
The answer is A. Disclose. Yes, you must. You are legally required to disclose all known defects. And if your seller refuses to do so, the best option may be just to refuse to represent the seller. But if you do go ahead and represent them, you must disclose to all parties. You have a duty of honesty and fairness to every party to the transaction, even those you do not represent. Non-disclosure by an agent is a very serious affair. And I have been involved in a lawsuit where one of our agents was aware of a foundation problem. The seller did not disclose it. The agent did not disclose it. And there was a settlement paid of around $35,000 and legal fees of far more than that. And a TREC complaint filed and certified by TREC. The agent got their hand slapped, and so did I because I was their broker. Okay. Yes, absolutely. And that's when they're probably going to fire you, which is fine. If you tell them, if you fail to disclose this foundation problem, please understand that I am legally obligated to do so, and I will do so to all potential buyers. Then they're either going to cooperate and disclose it themselves, or they're going to fire you. Okay? That's exactly right. That's right. Okie dokies. Question number 23. If a buyer chooses not to pay an option fee, does that ever happen in this market? Yes, it does. May they still have the home inspected? Y'all seem pretty sure about that. Answer is B. Correct. You are correct. The right to inspect is unrelated to an option period. What do they lose by not having an option period? Leverage in negotiating with the seller because they no longer have a unilateral right to terminate the contract. Okay, very good. 24, you've received an offer on a property you've listed. The seller does not intend to make any repairs and has asked you to write in special provisions that the home is being sold as is. What should you do? D, inform your client that as is language is already an option in the contract and no additional language needs to be inserted. You'll also want to inform the buyer's agent that the seller has stated they will not agree to any repair requests. Is that your answer? That is correct. That is correct. Paragraph 7D in the 1 to 4 family. Number 25, we're halfway through. The buyer had a home inspection completed during the option period. Now the option period has ended and the buyer wants to have a roof inspection and an HVAC inspection. Does the seller have the right to deny these requests? Have we given into groupthink? We got some A's. All right, well, we appreciate you being the foil to the right answer, which is C. The seller does not have the right to deny the requests because the buyer always has the right to conduct inspections as long as reasonable notice is given to the seller. That's paragraph 7A of the 1 to 4 family. Okay, right up before the day of closing, they can still be conducting inspections. After the option period, they've lost a lot of leverage for negotiating repairs, but they may still want to know what the condition, what they're getting into. That's exactly right. Yeah, that's a very good point. Okay, 26. If a buyer makes unreasonable repair requests, what options does the seller have? A, B, C, or D? Okay. How many A's do we have? How many B's? How many C's? How many D's? The answer is clearly A. The seller has the right to reject the request. Does the seller have the right to cancel the contract? Well, then it can't be D. It can't be all the above. What? No, they don't. They can't. That's not an option either. That's right. So B and C are clearly in error. So D must likewise be wrong. The answer is clearly A. They can reject the request. Number 27. The day before closing, the sellers change their mind and decide they're going to stay in the home. What are their rights according to the contract? A, B, C, or D? Everybody says D? D is correct. They have no right to cancel the contract. If they do, what happens? I want a very technical answer based upon a specific paragraph in the contract.
They can be sued.
Paragraph 15 gives them two options, right? They can sue for specific performance, or they could take the earnest money as liquidated damages. Paragraph 15. There we go. Number 28. If the buyer or seller defaults on the contract, what are the rights? Boy, this is too easy. We just talked about it. What are the rights of the non-defaulting party? A, B, C, or D? D, A and B only. Sue or take the earnest money. There's no such thing as treble damages. okay? I made that up. Number 29. How many of y'all got all the way to 29 when you actually were taking the test? Okay, not many of you. Okay, so as we read the question, try to commit to something, okay? The seller asked the listing agent to mention in the MLS that the refrigerator was included in the sale, but no mention of the refrigerator was made in the sale documents. May the seller now keep the refrigerator? A, B, C, or D? B says no, because it was offered in the MLS. How many B's do we have in the room? Okay, who's got a different answer? Okay, the A's have it. The answer is yes, the seller can keep that fridge because the offer in the MLS was just an offer. And because it was not documented in the contract, that offer is presumed not to have been accepted.
So why does it says in the MLS that the buyer's agent only gets 2.5% and they put 3% on the contract? Why does the MLS stand?
Well, first of all, what you write in that contract does not obligate the listing broker, because the brokers are not parties to that contract. And it says in that little paragraph on page 10, this is for informational purposes only. It's not part of the contract. So now I lost my place here. Where were we? We're on question 30. Okay, 29. So, that's right. So we're talking about the refrigerator. Just like the listing price in the MLS is considered what? It's an offer, right? It doesn't determine what goes in the sale documents. So if your buyer wants that refrigerator, listing agents, hear me loud and clear. I'm sorry, buyer agents, you better write it up. And where are you going to put it? In the non-realty items addendum. And what value are you going to assign to it? 0. Remember, the first paragraph says, for consideration, and you write in how much money. If you put 50 cents in there and it's a finance transaction, the lender's going to kick it back because they don't loan money on personal property. So in the non-realty items addendum on a finance transaction, that amount must always be 0. And then you can list everything, okay? Now, there is a better way to handle it. And that is for the buyer and seller to handle the sale of personal property items outside of the contract, just through a bill of sale. And then you just tell them, just Google bill of sale, and the forms will come up, and the buyer and seller can write the items in, and the actual value they're selling it for, $600, $200. This could be the lawnmower, it could be anything at all. And then they can transact that at closing if they want to, or any time before or after. But if it's going to be part of the contract, you're going to use the non-realty. Number 30, the buyer has submitted an offer to a seller, but then the buyer finds a home they like even better. Does that ever happen? How may they withdraw their offer to the seller? A, B, C, or D? The answer is D, either B or C. Okay, that's right. They can give notice to the seller they're withdrawing the offer. They can use the official TAR official. There's nothing official about a TAR document, but they can use this actual form, withdrawal of offer, and send to the seller. But the point is, there's no specific way they're required to give notice as long as they give notice of withdrawal. Okay. Number 31. A buyer defaulted on the sale contract, but is refusing to sign the release of earnest money until the seller agrees to give the earnest money to the buyer. Does that ever happen? All the time. All the time this happens. The buyer defaults, the seller's entitled to the earnest money, but the buyer has been coached by their agent. And this is what their agent has said. that seller can't sell the home until the previous contract is released, and we know they're eager to sell. So you need to dig in your heels and demand that they return the earnest money to you before you'll sign that release. If that hasn't happened to you in your career, you're new. Because it's going to happen all the time. Okay? So we're on 31. What is the correct answer? My question is that a good strategy? No, B. Because there are severe penalties for refusing to release the earnest money to the non-defaulting party. Is that true? Where do you find those penalties, by the way, mentioned? In the 1 to 4 family contract, paragraph 18D, and I'm going to give you all the answers and the references on all this, but it states in there that a defaulting party who unfairly refuses to sign the release of earnest money is subject to a number of penalties, including the release of the funds and attorney's fees that are required to collect them, and perhaps other penalties assessed by the court. So if you have a party who's in default and they're refusing to sign the release, you need to caution them, counsel them, go to paragraph 18D in the 1 to 4 family, and you may want to be more cooperative. All right. Number 32. A buyer owns the vacant residential lot next door to their home. No, a seller. There's another typo. Where did that pen go?
Should it say seller?
It should say seller. So I'm going to give everybody 100 on this one. A seller owns the vacant residential lot next door to their home, and they've asked you to sell it for them. Which listing agreement do you use? A, unimproved property. You say C, residential real estate listing. Let's hear the debate. Why A? And what?
Because then it says in the question, and it's just a lot, so it's probably not under.
It's a little bit of a trick question. There is no such thing as an unimproved property listing agreement. Okay, I understand why you went there, but it doesn't exist. The answer is C. Even though there's no house on the property, it's a vacant lot, you're going to use the 1 to 4 family. And here's the key. This is going to come up many times in your career. On unimproved property, you use the listing agreement reflecting the end use or the expected use of the property. A vacant residential lot, what do we expect to happen with that lot? A home will be built on it. So we use the 1 to 4 family. If it was 10 acres out in the country, what might we use? Farm and ranch. That's exactly right. So you use intended use. If it's in a commercial district, a half-acre lot in a commercial district, we would use what? Commercial listing agreement. Yes. Will?
Residential lot, 1 and
I'm sorry?
It's 1 lot and half of the lot.
Oh, okay. Is that a question or a statement?
Well, that's a question. You can consider it
So are they one property or two?
1.
Okay, you just use the 1 to 4 family. Yeah, 1.5 falls in the range between 1 and 4, but it's technically 1. Number 33. Your client has hired an attorney to draft the purchase contract. Are you allowed to use it? Yes, B, yes, C. You got 2 yeses. Okay, we got no A's or D's on this one. You had an A? No, you're only permitted to use promulgated forms. That's a reasonable answer. It's incorrect. I say it's reasonable because this is the drumbeat that's put into our head all the time. We can only use promulgated forms. But the truth is there are exceptions to the rule. One of them is when our client hires an attorney to draft the form. Another exception is when a principal to the transaction drafts the form. They can write, a buyer or seller can write their own contract. Even if they're not an attorney, they're a principal. Another exception is when there's no promulgated form that covers that situation. And in that case, we can use forms either drafted by the client's attorney or drafted by the principal or drafted by an attorney representing a third-party organization. Do we ever use any of those forms? TAR forms, HAR forms. Builder's forms would actually be prepared by the principal or by an attorney hired by the principal. Okay. They do because they're a principal. So be careful of this situation. You, as the above and beyond service agent, recognizes that an attorney needs to draft something. And I hear this particular scenario all the time. We want to do a lease purchase agreement. There's no promulgated form for that. There's no TAR form for that. An attorney has to draft it every time. Many good, well-meaning agents will say, I know a real estate attorney who will do that for $400, and it would be my honor to pick up the tab. Can you hear an agent saying that? Yeah, right. It's only $400. I'm going to make $12,000. However, you as the agent are not permitted to pay the attorney. Because I don't know if that actually creates a relationship or just gives the appearance of a relationship that you have the client relationship with the attorney. The payment to the attorney must come from a principal to the transaction. Okay. All right. Yes. Oh, the answer was B, correct. You are free. Yes, your client has the freedom to have an attorney draft contract forms, and you are free to use them in this situation.
But if you want to help them pay for it, you choose the attorney, and then you could kind of offer them something.
So I have to sit through these track classes every 2 years to get certified to teach Legal Update 1 and 2, and the students in the class are always asking questions just like that. Yeah, I know the law says this, but what if we do this and shift over here? And and the response of the Trek attorneys is always, if it looks like a duck, quacks like a duck, walks like a duck, it is a duck. And judges routinely see attempts to skirt the law as violation of the law. So never get too cute or fancy. If you're not supposed to pay for the attorney, don't pay for the attorney. If it's a $400 bill, don't discount your fee $400 to cover it and think you're going to get around it. That's right. Don't give them a $400 what, Kroger gift card you said? Exactly. All right, here we go. We are down to the buyer needs a 3-day extension of the closing date so the lender has time to prepare the closing documents. What are your seller's options? A, B, C, or D? Grant the extension. Okay. Anybody else? Who said D? Somebody brave person spoke up. All right, Pete, you've redeemed yourself with that D answer. That is correct. So let me explain. When the buyer fails to close by the closing date, they are technically in default, and the seller can then exercise the remedies of paragraph 15. That's right. However, a little bit of a gray area, because the closing date in the contract is not what? Quote, quote, time is of the essence. And that means it is a good faith target that both parties have agreed to. And the courts have consistently ruled that in situations exactly as described here, the lender needs another few days. Appraisals are running behind schedule. We're going to need another week because we couldn't get an appraiser out there. The courts have ruled that both parties are expected to cooperate in getting this deal to closing. So the answer is D. Technically, they could make a claim on the earnest money. Technically, they could sue for performance, but the way this typically happens and should happen is they grant the extension. And you need to know this so you can properly counsel your sellers in this situation. They're going to be like, well, then cancel the contract because we got another offer over here that's even better. Well, wait a minute. If the buyer decides to pursue this legally, the courts are, there's a really, historically, they have a good argument. Number 35, if a seller refuses to accept a full price offer, what are the possible consequences? A, B, C, or D? Oh, this was a tough one, wasn't it? A C or a D, but you went with D. Anybody else? What'd you put? Oh, y'all didn't get this far, did you? Okay, read the options there. The buyer could sue to enforce performance. The seller's in violation of MLS rules. The seller could have a complaint filed against them for violating the NAR Code of Ethics rule requiring honesty and fair play. Or the seller could owe the listing broker a commission. What's your best guess?
D.
The answer is dog. Dog. All the first three, no. But the seller could owe the broker a listing commission. That's found in paragraph 5B2 of the listing agreement. You produced a buyer willing and able to purchase on the terms offered. The seller doesn't have to accept the offer, but they owe you a commission. Yes.
And how do you know about doing that? If they're trying to-
You hire an attorney. Number 36, when must the MUD notice be provided? A, B, C, or D? Wow. Wow. We are all over. Okay, the correct answer, the only correct answer is D. Prior to entering into a sale contract. Okay, now let's address this because some of y'all are thinking as long as you get it in prior to closing. Okay, here's what happens. This MUD notice is a time bomb. You really need to understand this. If the MUD notice is not provided to the buyer prior to entering into a sale contract, that buyer has an automatic right of cancellation of the contract with the right to get the earnest money back right up until the day of closing.
Isn't that why though, that you should, that's why I put it's first listed. If you put it on the MLS and it's done.
Well, that's why the question says, when must it be provided? It doesn't have to be provided then at first listing or first contact, or it just must be provided prior to entering into a sale agreement. And if the listing agent says, hey, let's get all this buttoned up and I'll send the MUD notice and the HOA over in a couple days, seller's been out of town, we didn't get everything signed, you as the buyer's agent say what? Absolutely, no problem. Because you're going to preserve for your right. Even if they deliver that MUD notice 10 minutes after the contract is fully executed, the buyer still retains the right of cancellation. Okay?
Where does it state?
Okay, so on the MUD notice itself, there's a note right at the top that says this notice must be provided prior to entering into a sale agreement. It doesn't articulate in the note the consequences of failing to do that. But in the TECQ, Texas Environmental Quality Commission rules, it states the consequences. TECQ, that's the Texas government agency that is responsible for water districts. And there it states in the law that the buyer has the right of cancellation if they were not provided this notice prior to entering into a sale agreement. Okay. Number 37, if a buyer notices a broken window, there we go, threw some of y'all off with that one, a broken window prior to submitting an offer, where should the buyer request repair of the window? A, B, C, or D? Sale contract, repair amendment, closing documents, or in the non-realty items addendum? I heard some A's. Anybody else? The correct answer is A, 7D2 of the 1 to 4 family contract provides a couple blank lines where the buyer can write in any required repairs. And I've heard agents say, oh, we'll just do that during the option period when we submit our other repairs on the amendment. And I guarantee you're going to make some listing brokers and sellers very upset. If you know that a repair needs to be made when you're writing the offer, you need to mention those repairs in the offer. That is part of it, okay? Now, a lot of things you don't know when you write the offer. That's why you have inspections. But if you know up front that roof has got to be replaced, that window has got to be repaired, the AC unit has got to be working, then you put that in the offer, okay? Number 38, if a sale contract is executed on Thursday, when is the earnest money and option fee due? A, B, C, or D? What about C? The answer is D, both B and C. So Thursday, day one would be what? Day one is Friday. You start counting the day after the execution or after the effective date. So if the effective date is Thursday, Friday is 1, Saturday 2, Sunday 3. That day 3 falls on a weekend or federal holiday, so it defaults to the next day, which is Monday 5 p.m., unless that Monday is a federal holiday, in which it would bump to Tuesday. There we go. So that's why D is the correct answer. 39, is the pool skimmer included in the sale of the home? This is such a smart, well-trained group. The answer is A. Yes, the pool skimmer is included because it is an accessory. 40, what are the 3 elements that constitute the property? Soil, sky, and structures. Is that your position, Nancy? That's very poetic, but incorrect. Land, improvements, and accessories. Where would you find that? Paragraph 2 of the 1 to 4 family contract. Remember, paragraph 1 identifies the parties to the contract, buyer and seller. Paragraph 2 describes the property. That's where you put in the address, the legal description, and then there's a 2A, 2B, 2C. And it says this property includes land, improvements, and accessories. There we go. 41. If there are mineral rights owned by the seller, what happens to them when the property is sold? A, they stay with the seller. B, they stay with the seller only if a grantee addendum has been signed. C, they go to the buyer. D, they go to the Mexican government. Yeah. Viva la Mexico. So, we're going with C, going with A. Well, the contract is very clear. They go to the buyer. The answer is C. And that is found in paragraph 2E of the 1 to 4 family contract. And it specifically says, unless those rights are reserved by the seller in a separate addendum, they are presumed to go with the property to the buyer. So the answer is C. They go to the buyer. Did I say something different?
No, it just says that B, if the seller only granted a grantee addendum.
What is a grantee addendum? I made that up. There is no such thing. Yeah, it would be an addendum called, and it's roughly entitled reservation of minerals. But look on the keyword reservation and you'll find it. It's where the seller reserves those minerals and they don't go with the sale of the property. If the seller does not do that, they go with the property. Okay. 42. If the standard printed exceptions in the title policy are amended to read, quote, shortages in area, what does that mean? Shanna, we're going to let you answer this one. The pressure is on. A, B, C, or D? Okay. Okay, I hear a C from Anna. She's saying shortages in area are not covered if you get the extension. C? We're going to see if our title rep agrees. Hint, hint. This is a smart group, Shanna. Be careful about disagreeing with this group. The answer is C. Shortages in area are not covered by the title policy. Even if you pay that additional 15% premium, it eliminates the other exceptions, but shortages in area remains as an exception. So y'all got that, so congratulations. Number 43. Where does a seller disclose that a property is subject to mandatory membership in a property owners association? A, B, C, or D? The HOA addendum, the resale certificate, the sale contract, or the seller's disclosure notice? I have yet to hear the correct answer. Anna, you are not getting credit for that. But that is the correct answer. D, the seller's disclosure. There may not even be an HOA addendum, right? And a resale certificate, that's typically produced after the sale contract is put together, okay? And there's no place in the well, I'm sorry, it does say it in there, but the disclosure is made in the seller's disclosure notice. In the TREC disclosure, that's paragraph 9. All right, number 44. If a property is subject to mandatory membership in a property owners association, is the seller required to provide an HOA addendum? Yes, no, or only in certain circumstances? Let's hear the yeses loud and proud. Let's see your hands. Yes, if I ask you to raise your hands, it's for purposes of public humiliation. You should know that by now, okay? The answer is no. No. It's a very interesting comment found in the 1-to-4 family contract. That's why I recommend that it be read occasionally, okay? And after it goes through all this information about mandatory membership in a property owners association, in big, bold language, the contract states, if the buyer has concerns about these issues, the HOA addendum should be used. We typically think of this as a seller's disclosure, right? It's not. Now, as a listing agent, it's best practice to go ahead and prepare an HOA addendum. Why? So you can write the terms in favor of the seller, right? You can maximize the amount of money the buyer is going to pay before the seller picks up the excess. So there's value in the listing agent getting this from the seller, but it is not a seller's disclosure. The 1-to-4 family specifically puts the onus on the buyer if they have concerns about that issue, okay?
So that's the whole thing about the property information. So there's like a little check mark that says buyer does not require.
The subdivision information, yes. No. In the HOA addendum, that's where that language appears. In the HOA addendum, it describes who's going to provide subdivision documents, if anybody, and if so, who's going to pay for them. All that's in the HOA addendum. But the 1-to-4 family says if the buyer's concerned, the buyer needs to get the addendum and use it. Best practice. but not legally required. 45. Can an HOA foreclose on a property for unpaid HOA fees? Yes, A, yes, or B, yes, unless it's the homestead of the property owner, or no, the HOA can file a lien but not foreclose, or no, it's the property, unless it's the property of a non-occupant owner. The answer is A. And I refer you to paragraph 6E2 of the 1-to-4 family contract, where it states as a warning to the buyer, there may be unpaid HOA fees on this property. And if so, the HOA can foreclose, it uses that word, can foreclose on the property. Therefore, what should the buyer do? Get the resale certificate, use that HOA addendum, decide who's going to order those documents and who's going to pay for them, and then review them, because the resale certificate will tell, among other things, if there is pending litigation either against the HOA or the HOA against a homeowner, and you might be buying a property that's subject to foreclosure. Okay. Yeah, that would be paragraph 6E2 of the 1-to-4 family, and this will be in the notes that I give you after class. Yes, yes. As a listing agent, you'll often see if they've prepared the HOA addendum, they'll say the buyer does not require the subdivision documents. As a buyer's agent, you don't want to accept that. You want the documents provided as a protection for your buyer, and if there is a financing involved, the lender will require the subdivision information because they don't want to loan money on a property that could be foreclosed upon.
Is that public record?
If you're buying the property, or, should you, on that addendum, when you're the one providing that HOA notice, request that the seller pays for that, and what kind of charges is that?
So best practice, if you want to know what the charges are going to be for providing all this information, is you contact the property owners association. And that is a really smart thing to do. If you're a listing agent, when you're doing all your setup for the listing, you make the call, you find out they're going to charge $450 for the resale certificate. Typically, this other subdivision documents will be provided without charge, but they do charge for a resale certificate. Then when you write up that HOA addendum, which you're not required to do, but it's best practice that you do, you put $450 in that line.
And if the title company is the one who acquires that foreclosing regardless, isn't that true? Does the title company get that information?
So the title company will order the documents in accordance with the instructions in the HOA addendum and bill the parties appropriately. But it is the responsibility of the agents, our fiduciary, to write it up and make sure that the best interests of our clients are protected. Okie dokies. 46. In the third-party financing addendum, what two things must be approved? The interest rate and the origination fee, the foundation and the roof, the husband and the wife, the property and the borrower. I'm going to cry. Thank you. That made it worthwhile. The property and the borrower. Come on now, guys. Come on. What must be approved? The third party the borrower has to get approval, right? Do they qualify for financing? And the property. We may have a great borrower, 800 credit score, $1 million in the bank. What if the property we're doing FHA financing, there's a hole in the roof and a crack in the foundation? Oh, that was a trick. But D is the correct answer. 47. If a property fails to appraise for the sale price and an appraisal waiver has not been signed, when must the buyer give notice to the seller in which to cancel the contract and get a refund of the earnest money? A, B, C, or D? A, during the financing period, B, immediately upon receiving the appraisal. C, anytime prior to closing. D, at least 3 days prior to closing. The answer, as stated in the property approval section of the third-party financing addendum, is at least 3 days prior to closing. Correct answer is D. If they give notice 2 days prior to closing, they're going to lose their earnest money. 48, who has the right to speak to the buyer's lender regarding the buyer's qualifications to obtain financing? The buyer, the seller, the listing agent, or all of the above? And this, I've had agents call me, buyer's agents call me very upset. The listing agent said they want to talk to the buyer's lender so they can determine for themselves if the buyer's qualified. And we gave them a pre-approval letter. Should the buyer's agent be upset? The answer is, what is the correct answer? A, B, C, or D? Correct answer is D, all the above. And it is so stated in paragraph 5A of the third-party financing addendum. All parties have the right to contact the lender. The listing agent can show the third-party financing addendum to the lender where it states right there that all parties have granted permission for the mortgage company to talk to all parties to the transaction and their representatives. I'm sorry?
Isn't that the same thing? And what would that, the tiller, isn't that where it gives you the permission to discuss those things?
No, it's the third-party financing addendum that does that. Paragraph 5A.
Right.
No, the Truth in Lending Act is TILA, and the Real Estate Settlement Procedures Act is RESPA. They're not the same thing. And RESPA deals primarily with referrals among closing companies.
The reason I'm asking you is because it says granting the permission to receive information about that.
Well, perhaps there is another document that does that we don't typically use in our business, but in our business, it's the third party that we use that gives us permission. Yeah. 49. Does the listing agent have the right to change the terms of the listing agreement? A, B, C, or D? The answer is no. The listing agent may not modify the terms of a promulgated form. B, no. Only a principal to the transaction may change the terms of a contract form. C, yes, with the listing broker's permission. D, yes, if an attorney drafts the language. The answer is cat. Yes, think about this. Who are the parties to the listing agreement? The listing broker and the seller. The listing broker is therefore a principal to the transaction. A listing agent, with their broker's permission, acting on behalf of their broker, can absolutely change the terms of the listing agreement. In fact, some brokerages have gone so far as to draft their own listing agreements, and they don't even need an attorney to do it because they are a principal to the transaction. So just always keep in mind who are the parties, who are the principals, who's representing who. Number 50. What is the penalty for an agent changing a TAR promulgated form? A, letter of reprimand. B, requirement to take a 3-hour contracts course. C, censure for practicing law without a license. D, silly agent, TAR doesn't promulgate forms. The answer is D. Who promulgates forms in the state of Texas? TREC, and only TREC. All right, you thought that was it. I have a bonus question for you. No extra charge. And Dario, I'm going to give you first shot at this one. Okay? If the seller pays for OTP for the owner's title policy, may the listing broker or the seller require the use of a particular title company. And you hear that, you see this in almost every single listing in the MLS, and it goes like this. If seller pays OTP, use Envision Title Company. My question is that legal? Yes or no? So here are your options. I shouldn't have asked you yet. A, yes, of course they can do that. That's what listing agents always say in the MLS. So it must be right. B, no. The choice of title company is always a matter of negotiation. C, yes, but only if the seller also pays for the lender title policy. D, no. The buyer's agent writes the offer contract, so the buyer gets to choose. A, B, C, or D? There's only one correct. All right, who says A? Who says yes, of course? That's what the listing agent says in the MLS, so it must be right. Who says B? The choice of the title company is always a matter of negotiation. Who says C? Yes, the seller can dictate, but only if they also pay for the lender title policy. Who says D? No, the buyer's agent writes the contract, so the buyer gets to choose. The answer correct, which nobody got, is C. Yes, the seller can dictate the choice of title company if they pay for OTP and the lender's title policy. If they're only paying OTP, they cannot. I am going to read to you as my final hurrah directly from the TAR website addressing this issue. If the seller pays for both the owner policy and the lender policy from title insurance, the seller can pick the title company without violating RESPA. However, if the buyer pays for the owner policy, the seller cannot condition the sale of the property on the buyer purchasing the owner policy from a particular title company. Rather, the buyer would get to pick the title company. So the seller gets to pick if they pay both. The buyer gets to pick if they pay OTP. It's presumed they're going to pay lender. In situations where the seller pays for the owner policy and the buyer pays for the lender policy, which is typical, right? RESPA application is less clear. At least one court has held that where the seller paid for the owner policy and the buyer paid for the lender policy, the seller did not violate RESPA by insisting on a particular title company for the owner policy. That kind of makes it sound like it's okay what listing agents are saying, but wait, there's more. The court explained that the seller did not require as a condition of sale that the buyer use that same title company to issue the lender policy. However, here's the but wait. The Consumer Financial Protection Bureau, the government agency that enforces RESPA, has yet to take an official position on the law's application in this scenario. Therefore, if a seller wants to avoid a possible violation of RESPA, they should not insist upon a particular title company for the transaction unless the seller is paying for both the owner policy and the lender policy. This is going to come up again and again, not in this market, because in this market, what do we say to the listing agent? Whatsoever thouest wishes. Whatsoever you want. But in a normal market where we're arm wrestling for our preferred title company, such as the one that Shanna represents, and it is an arm wrestle, we sometimes have to have this information to educate the listing agent that they do not get to dictate the choice of title company unless their client is paying both. And if they want to pay both, then we'll gladly go with their choice. Okay?
I found that most people do not want to lose a deal over title.
And as a fiduciary, you never want to lose a deal on behalf of your client over your choice of title company, right? You always want to put your client's best interest first. But I'm also going to say things go better when you're working with your preferred title company. If you're sending Shanna 12 deals a year and you have a choice of working with Shanna or a title company on the other side of town that you've never worked with, who do you think is going to be more responsive to you? Who's going to cut you a break when there's actually not an opening at 3 p.m. on Friday, but you've sent her 12 deals this year? There is value to your client in working with your preferred title company. Just keep it in the proper perspective. Don't lose the deal or alienate another agent over that. Okay? Okay, guys, have you enjoyed this as much as I have? Well, I appreciate y'all playing along. I'm going to go ahead and stop the recording, and I will send you, every one of